All right, guys, welcome. Hope you're doing well. Hey, if you didn't get a chance to join us on the webinar, we're doing a little synopsis here. The recording of the webinar is also available, and there were some great questions from the audience, so that might be helpful, but this will be a little cleaner and a little quicker. So, we know the recent PHH decision is in. Everybody's talking about it in our industry, the idea of the CFPB having some constitutional issues. Probably doesn't surprise all of us. I think, if you grew up understanding checks and balances, you wondered, maybe how a organization like the CFPB would exist in that world, so to speak. But we're going to jump into the decision, spend some time talking about it. We're really going to go back to the very beginning and talk about where this all started, because we really have kind of a lot going on with this topic. If we haven't met before, there's some background information about me on the screen, but I currently run Deal and Associates, also known as Deal Mortgage Training and Compliance, and we serve the industry that I worked in for many years, and we strive to provide good information so that when you're doing, whether it's FHA underwriting training or PE or CE, that you're getting good info that you can really put to work and use. And it's not just time that you're burning, but there's value to it. Working in the industry, and you may know this from your personal experience, it's probably not hard to think of a time when you felt like you were in a course or a training where it wasn't a good use of your time. And that's what we strive to do. So we're always talking about these kind of topics like the PHH decision. History of the company in 30 seconds. We started training conventional underwriters how to underwrite FHA loans in 1983. We added the SAFE Act PECE in, and we think that your time matters. And even though you have to meet these requirements, that your time is valuable and you should spend it doing things that will give you information that you can use day to day. So that's what we focus on. And obviously to the right, you know that compliance is a big part of our world, especially since the crash. And that's probably a perfect lead in to talking about this case. So we'll spend a few minutes framing this out. Why? It's a great story. It is high courtroom drama at its finest, and it affects all of our world, so to speak. And we're very vested in this industry that we serve. And these strike a chord with all of us when things happen, like the creation and the implementation of the CFPB, as well as rulings like we saw here with PHH. So we'll spend some time talking about that. We'll frame it out a little bit at the beginning and frame out a little bit about both sides. Then we're going to spend a little bit of time after that talking about what the result was. In other words, once we have this decision, what does it really mean? And we're going to do that by actually going in and digging into the ruling itself. Along the way, just as members of the industry, you start to think, well, how is this going to affect us moving forward? And what is the message that we take forward? So we'll spend some time on that as well. Excuse me. If you go back to the beginning, you really have to go back to January of 2014. We know that the PHH case resulted initially in a fine to PHH of $6 million. And that both PHH and the CFPB weren't completely happy with that result. So it was appealed. And where does the appeal go? It goes back to the CFPB and the current director. And that fine gets increased to $109 million. And so what happened on April 12th? The opening arguments of this challenge, if you will, to the most recent ruling at that time. And really, you had an amazing scenario here. This was April 12th. There was a buzz around DC like nobody's business. The courtroom was packed, and we had really strong litigators on both sides of this argument. On PHH's side, you had Ted Olson and also Mitch Kiter and his firm. Some really big names in DC representation, if you will, the mortgage industry. And on the other side of the table, you also had some big names with the CFPB's lead litigator. And I think it's Lawrence DeMills, but he was also with the FTC and was responsible and was involved with the do not call legislation. So, big time litigators, if you will, on both sides. Ted Olson, we joke that he handled some little cases like Apple versus the FBI and Bush versus Gore and the hanging Chad argument in Florida for the recount. So, you really do have two of the top people in the field arguing both sides of this. Now, on your screen, you see the slide. This is what Ted Olson says, and it was amazing. I'm sure the folks that were in that courtroom were probably silent by these words. But you can see how it starts out. Thank you, Honor. May it please the court. The overarching and grievous separation of powers argument presented by the CFPB arises in the context of an astonishingly capricious and unlawful agency decision. And then he goes on to say the director ran roughshod over clear provisions of federal law. What are we talking about here? RESPA Section 8. And he prohibited conduct expressly authorized by that law. In other words, RESPA does allow services to be provided and charges to be made. RESPA doesn't allow you to mark those charges up or pay people that aren't doing work that's commensurate with that. So, but in this case, pointing right back to captive reinsurance being, one of those services, in mortgage insurance being one of those services that could be, considered in this category of settlement costs. It also says that, and he also said that agency director disregarded, retroactively overruled decades of administrative and judicial application of the law and industry reliance on it. There was guidance that HUD issued based on a request from Countrywide at the time. I believe it was in 97. And it talked about how captive reinsurance could be done in a way that would be compliant. So that's an example of that. And then it also says disregarded the statute of limitations. In the original $6 million fine, the judge that handled that case had mentioned the statute of limitations when arriving at that $6 million number. When it went to 109, that statute of limitations was ignored, if you will, or not considered. So, and then you see imposed draconian remedial punishment that Congress did not give the powers to this agency for under these circumstances. So you can see these words, and these are weighty words. These mean a lot, especially to this company and to everybody in our industry. We know this is the first significant or serious challenge to the CFPB, and it goes right to the heart of the constitutionality of the group. So that's how this all started. And if you listen to the closing remarks, which I will attempt to give you guys as well in the original form here, I'll flip over to this and pause the screen briefly. So you might see my screen flip around, but I think you'll find it's well worth it when you hear the words and the actual recording from the courtroom that day. So listen up. I'll turn this up and then we'll jump back into the slides. But this is how Ted Olson is closing out this argument and really says a lot. Again, kind of going back to the constitutionality of this whole issue and the constitutionality of the agency.
Approach to separation of powers is appropriate. Morrison versus Olson. That is what the Supreme Court of the United States did, is apply a holistic approach and talk about the fact that the independent counsel there was appointed to a limited term for a limited purpose, and whether or not that decision is right or wrong in retrospect, there was a very careful constraint by the Supreme Court of we have to look at the entire picture. Well, let's look at the entire picture in this case. You have an agency run by a director that doesn't have to consult with anybody else. The FTC and some of those other agencies can only have 3 people from one party in the agency. There's a division of authority. There's separation. There's appointments at various different times. So this is all power concentrated in one person. The president does not have the power to remove except for inefficiency, malfeasance, or some violation of the law or something like that. The president can't remove this individual. The next president can't until his term is over. If there can't be an appointment, he continues on. He doesn't have to go to Congress with respect to his funds. He doesn't have to consult with the executive branch with respect to communications of Congress. He can hire people that are in ways that are independent of restrictions on federal employees, and can fire people and can set their salaries. This is, if you wanted power to run this country, and this agency took over the responsibility of something like a store of different other agencies with statutes all the way across the book. So it's very broad authority. It's not like the Social Security Commission. It's not like the FHFA, which is a limited degree of authority and must share it with the Board of Advisors, including the head of the Treasury, the Secretary of Treasury, and so on and so forth, and a limited scope with respect to the GSEs. But this is a very broad grant of authority over many, many different statutes to one individual who doesn't have to pay any attention to the president or the Congress, can do anything he wants. And what we see here is a violation systematically of statute after statute after statute to impose a $109 million penalty out of the blue on this industry and this company that was following the law. That is unconstitutional. It's an unconstitutional agency, and the steps that were taken are unconstitutional. The decision of this director cannot be upheld. The decision must be vacated, and I do hope that the court will weigh in on these statutory violations because it's very, very important to this entire industry. Reinsurance is a very legitimate business. It is very important to certain people. The existence of reinsurance is not against the law. It's not prohibited by RESPA, and referrals are not prohibited only where there is not compensation for actual services. So it's very, very important that the court pronounce where there's a violation of the statute by this director. There was a violation of the statute, and the director who was appointed by the president pursuant to a provision that we submit is unconstitutional. He cannot hold that job. You cannot strip the removal provisions and then say, go back and keep doing it, because he was appointed to a position that had those removal restrictions on it. They're unconstitutional. He cannot hold that office. Someone else will have to be appointed to an agency that Congress should come back and create in a constitutional way. Thank you.
Thank you, counsel. Thank all counsel for excellent briefs and arguments, including all the amicus briefs, which were very helpful. Cases submitted.
All right, so there you go. We listened to the actual recording of those words being spoken. You can see the keys that we really think were important on the screen, but these are strong arguments, weighty words, and that's what teed up the decision on the 11th. This was all April 12th. Now, when you take a look at what the decision is and you start to dig into it, when you look at the very beginning of what was written, you see what you see on the screen. Before that, you see some of the players that are involved here, and obviously everybody in our industry, in the mortgage industry, and every related industry is represented, as part of this. So you do have NAR, National Association of Realtors, that were represented. Other companies, banks as well, that were listed. But, when you see what you see in front of you right now, you start to get right, again, back to that constitutionality of this. And you see the intent, I guess, of the structure within our government. And what we know is basic, maybe more 101 stuff from our civics classes. But you can see that this kind of frames that out. When you dig into it, what you start to see talk about is, there are agencies that are controlled by the president, where the president has power over that agency. There are also agencies that Congress creates. In that case, there's typically either oversight or there's more of a team approach, if you will, to running that agency, and not a single director without any checks and balances. So the really telling quote at the bottom really says it all. Therefore, no independent agency exercising substantial executive authority has ever been headed by a single person until now. So again, weighty words in this decision that was handed down. Now, there's a couple of key things here. PHH did argue that the structure or the single director format was unconstitutional because there wasn't a check there, and the court agreed with this. So there's the good news. And what you see in a lot of the headlines right now is the CFPB is unconstitutional, right? And it does say that in here, but it also says what's the fix, okay? PHH in their argument talked about shutting down the CFPB, and in this case, the quote that you see on your screen is directly from this decision, talking about a narrower remedy. In other words, not all of what was hoped for, maybe on the company side or maybe some industry groups as well. So what will happen is it won't affect the ongoing operations. That's why you're seeing some things right now with some of the proponents of the very strong proponents of the CFPB, like Elizabeth Warren, talking about the fact that this really doesn't make any difference. So you really see both sides coming out here. You see the ones that are more in favor of small government talking about the fact that this is an important step forward, and some of the proponents of really the CFPB, including Elizabeth Warren, talking about the fact that this won't affect everything. And in reality, it's a little bit of both. So what will happen? The president will be the check. In other words, the director will be tucked under the executive branch, and there isn't a cause required to remove that director. So in other words, if the president chose to, that they could remove the director at any time for any reason, and not only for certain reasons, which is really where it's kind of pigeonholed right now, if you will, at least in our humble opinion. So what happens to the company in this case and the $109 million? First of all, the whole industry was watching this, and overall, what we've heard from a lot of people in the industry, this is a good first step. It is important for there to be give and take when it comes to agencies that regulate industry, right? We know of instances where either agencies, maybe we feel they've overreacted, or we've seen sometimes companies or even banks that we felt really stepped out of the bounds of what they should do. Either one of those is not a good thing. So the overall baseline that we've gotten from industry is that most people feel like this is a good thing. It's a step in the right direction. It doesn't change everything, but it is an important step, and it is the first challenge. So the 3 points that were addressed in this were Section 8.1, and talked about the fact that services can be provided, settlement services can be provided. They can't be, marked up arbitrarily, but if they're market rate, then it's not seen as an extra cost to the consumer. And again, you'll hear a lot of attorneys and experts weigh in on this. This is just our humble opinion, our take on this. So take it for what you will. If you need legal advice, certainly contact your attorneys or regulators in those cases. So again, kind of talking about some opinions here. The CFPB departed from the prior interpretations in making the $109 million decision, if you will, and the court agreed that their due process rights were violated in doing that. And what the court said is that the CFPB would be free to come back and show that more than market value was paid for these services, and if that's the case, then that could be the basis of any fines or penalties against the company, but that would have to be really the basis of it. In other words, show that more than market value was paid, and also would be subject to that 3-year statute of limitations, which the $109 million number did not consider. So again, some significant pluses here, some significant accomplishments. Now, what does this mean going forward? Well, we know RESPA has to deal with settlement services. We know there have been decisions on things, or at least a lot of talk and communication about things like marketing services agreements. So really, you're going to hear a lot in the coming days about what this really means to all of those next thought processes that we have that relate to this. And right now, our opinion is you're really seeing the court say that RESPA is being interpreted as it was written in the books and interpreted by HUD. So if there's going to be anything outside of that realm, then it could be subject to the same same vacation of, the same actions that you're seeing right now from this appeals court. So also you start thinking about this a little further, and you think, well, is this really going to push the CFPB to spell out more of what behaviors they want to see and what rules that would govern those. The CFPB cannot, the rules of RESPA are there, the interpretations of HUD are there. Certainly they can, look at those items as well. But if they want to prevent certain activities, is this really going to push them to spell out those types of things? They have the ability to write new rules, right? So is this going to push for what some in the industry have called for, which is, tell us what these rules are that you want us to follow, put these in writing, give us this guidance. Until now, there's certainly been, a criticism of the agency of ruling by enforcement. So will this push them to put more into the rules? Certainly could. And we'll also be all watching to see what the future interpretations, the developments, and really how this all moves forward. So we appreciate you spending some time with us today. We encourage you to read what the court decided. It's a part of the webinar. And it really, I think, being a player in this industry, you want to take a look at that and see what that means. And we also look forward to having more ongoing communications about this and all the myriad of things that are going on in our industry. We know we have HMDA changes coming up. We know we have a new 1003. We have a variety of different things down the road. We certainly try to put that into everything we do, whether it's PE or CE or any of the training and the services that we provide. But we appreciate you joining us today. We hope the information was helpful to you and maybe getting us all on the same page, giving us some context a little bit. And we wish you guys a great rest of the year and finishing the year strong. So great industry and a lot of good things going on. Certainly some interesting developments as it relates to PHH. Thanks a lot, everybody, and take care.